Yes. Martin says they will do for the claimant. Who appears for the defendant?
Lord M.O. Obatikene, appearing with me are my learned friends Aliyu Jibril and Joy Umen Sofo. Lord, we are holding the brief of Bimbo at Lola. Our humble appearance is for the defendant.
Can you please kindly mute your mics, gentlemen? Can you please all mute your mics? Thank you. Now, this is the court decision. The claimant commenced this suit via the complaint and state of facts filed on the 11th of February 2022, seeking the following reliefs against the defendant. One, the declaration that the act of the defendant terminating the claimant's employment is unlawful and illegal against the terms and conditions of the employment of the claimant, as stated in the employee handbook. Two, the declaration that the claimant be reinstated forthwith to its position with all the claimant's accruing benefits, which includes promotion, profit sharing, bonus payment, and any other allowances paid while the matter lasted in court, and then an order that the claimant be paid the sum of 794,241.5 per month, and the claimant's quarterly allowance of 750,905.50, and the medical bill of 894,500 incurred by the claimant, which was approved by the defendant, will be paid to the claimant forthwith. For an order directing the defendant to pay the sum of 100 million naira only as compensation to the claimant for the pain caused the claimant due to the willful and wrongful termination of the claimant's employment without any wrongdoing. And then 10% monthly interest on the judgment sum from the date of judgment to the until the final liquidation of the same by defendant. And then finally, 6, the cost of this action. Now, defendant entered appearance and joint issues to the claimant, and the matter was set down for hearing, and the claimant at trial, the claimant testified that CW adopted his deposition. Well, I've summarized the proceedings at trial and then the submissions of counsel in the final address. I'm going straight to the decision. This is what is important to counsel and parties here. The submission you can always read. Now, this is the court decision. Having carefully considered the submissions of counsel and the position of the law as it is, and the position of the law, it is the employee who alleges that there has been an infraction of the terms of his contract that bears responsibility of placing this contract before the court and to demonstrate how it was violated by the employer. Union Bank has Salahuddin, cited here. Now, I find that the above dictum applies in this instant case. It is neither the duty of the court nor the defendant here to establish the case of the claimant for him. The claimant here relies upon Exhibit C3 as the terms of his employment violated by the defendant. How the claimant expects this court to rely upon a single page from a document that is not before the court is frankly astonishing. Where is the complete document? Not only is this page unidentifiable and unreliable, the court cannot determine the context within which the contents of this page were made and to whom they applied and are so whom. Now, the claimant also made an attempt to shift the onus to the defendant to place before it set terms of the contract between the parties. It does not work that way. The burden only shifts where the claimant successfully discharged the evidential burden placed upon him as the party who alleges. There is no obligation on the part of the defendant here, and I'm in complete agreement with the dictum of my learned brother Kanyip NICN in suit number NICN/LA/122/2016, Ms. Rosalind Ekeng vs. International Energy Insurance PLC, delivered on 18th of June 2019, that before the condition of service become binding on an employee, he must sign and date same. Hold on. The dictum of Kanyip J in the above manner that it is not necessary before the condition of service becomes binding on an employee, he must sign and date same. In this instance case, the claimant already agreed to be bound by Exhibit D, to which he accepted the terms of Exhibit C1, which provides on page 2, paragraph 1 that, and I quote, your employment, including the probationary period, will be governed by the terms and conditions of service, a copy of which will be provided to you. Any amendments or additions thereto will be advised to you in accordance with the bank's policies. Can you indicate your acceptance of the offer and the resumption date by signing and returning to us the duplicate of this offer, end quote. From the above, it can be safely inferred that the claimant accepted the terms, having resumed with the defendant and worked until the termination of his employment. I further find that the Exhibit G2 being the 2019 version is the excellent employee handbook in operation as at the exit of the claimant in 2021. It is therefore binding upon the parties and would be relied upon in the determination of the rights of the parties here and as a whole. Accordingly, I find that the defendant was entitled to rely upon clause 7.8.1 of Exhibit D2 and terminate the claimant's employment by paying the claimant the prescribed 1 month salary in lieu of notice as clearly stated in Exhibit C2. This represents the agreement of the parties and they are bound by the agreement. See the case of Olaniyon versus the University of Lagos citation provided. I therefore find no violation of the employment contract by a defendant and I hereby refuse reliefs 1, 2, and 4 for being without merit. They are hereby dismissed accordingly. For relief 3, the issue here is quite straightforward. Exhibit D2 is quite straightforward. Exhibit D2 in the same clause 7.8.1 provides for the payment of 1 month basic salary in lieu of notice. Exhibit D3 clearly shows the claimant's 1 month basic salary as 287,145 naira 25 kobo. This was what was paid to the claimant at the termination of his employment as shown in the D4, the precise entry of 28th of May 2021. This is also the date of Exhibit C2. The claimant has shown no evidence of an entitlement to the sum of 794,241.51 as monthly basic salary, and therefore I must refuse this leg of the relief as unproven. Now, I must also make a similar finding as to the head of claim for the sum of 894,500 for medical expense, as there's no evidence at all placed before the court showing how the expense was incurred, the precise date it was incurred, and the approval allegedly given by a defendant to incur this expense, and what contractual terms permits the making of such a claim for refund. This head of claim is completely without merit and unproven and so on. Finally, as to the head of claim for 750,905.50, representing the claimant's quarterly allowance, I find that the defendant has shown that it paid the claimant his allowances up to June 2021, but based on the outstanding loan obligations of the claimant, the defendant set off these payments as part of the loan obligation. I cannot fault the defendant here, as the apex court in the case of Lewis and UBA citation provided has held that the mere cessation of employment or even the death of an employee does not extinguish the obligation to repay a loan taken out by the said employee. I therefore find that a reform must and hereby fails for lacking the merit, is hereby dismissed accordingly. As a necessary consequence, release 5 and 6 must also fail and are all hereby dismissed. On the whole, and for the avoidance of that, the claimant case fails and is hereby dismissed in entirety, nor does the cost judgment is settled accordingly.
As the court pleases.
As the court pleases. Lord, we thank you for the well-considered judgment.
Thank you. Unfortunately, I'm not sending it to Jos. I'm not sending it to Lagos. I'm sending it to Jos. So you Lagos people, you know how to get it from Jos.
No problem, my Lord.
It will be in Jos by Monday.
As the court pleases.
Thank you. Now, for Mr. Adubami and UBA, do we have counsel? I see Ifoma Okeke is with us.
Yes, my Lord. I am the Nishina for the claimant.
Sorry? Can you kindly mute your mic if you're not on the in this matter?
Nishina. Hello, my Lord.
Yes, Shina. For the claimant, right?
Yes, sir.
You're holding brief of Zaruma?
No, we are in the same chamber, sir.
All right, that's good.
Same office.
All right. Ifoma Okeke. I see Ifoma Okeke on the platform. Anyway, this is the court's decision. The claimant here commences action via the writ of summons and statement of claim filed on the 21st of October 2021, seeking the following reliefs against the defendant. I've listed out, well, let me just read out. A declaration that the parties to the subject matter of this suit are bound by the doctrine. The reliefs here are numbered A to T. I'm not going to waste time reading all of this. You know what the reliefs are, but let me just read it anyway. Declaration, parties are bound, and then which makes it mandatory obligatory for all the parties to fully respect the terms and conditions of the contract of employment, which they have freely entered into in the offer letter dated 23rd of February 2007. Declaration and termination of the claimant's employment, which was done without notice and without payment of 1 month salary and a year of notice agreed upon in the offer letter of 23rd of February 2007, and the payments and non-payments of entitlement constitute a breach of contract of the employment and therefore unlawful. C, a declaration that the failure or refusal of the defendant to confirm the claimant's employment at the expiration of 6 months probationary period, but continue to use the service afterwards till 20th of May 2008, when the employment was terminated, is a breach of the contract of employment and it is exploitative, inequitable, and unlawful. D, a declaration that the claimant had been underpaid the salaries and allowances throughout the period of his employment, and that the claimant is entitled to be paid all the shortfalls in salaries and allowances. E, a declaration that the underpayments of the salaries and allowances and non-payments of the claimant's yearly entitlements throughout the period of his employment is exploitative and illegal. F, a declaration that the claimant defendant's act of non-remittance of some deductions meant for the pension contributions and all deductions for the National Housing Fund to the appropriate bodies is illegal and exploitative. A declaration, G, a declaration that the lien placed on the claimant's salary account despite not being indebted to the defendant from 20th of May 2008 up to date is wicked and illegal. H, an order of this honorable court directing defendant to pay the claimant the sum of 8,734,449 naira 20 kobo, being the shortfalls in monthly basic salary and monthly allowances from March 2007 to April 2008. I, an order of this honorable court directing the defendant to pay the claimant the sum of 320,983 naira 85 kobo, being his total unpaid emoluments, entitlements payable yearly in advance but were never paid. J, an order of this honorable court directing the defendant to pay the claimant the sum of 202,662 naira 80 kobo, being his unpaid basic monthly salary for May 2008. An order of this honorable court directing the defendant to pay the claimant the sum of 318,709 naira 60 kobo, being unpaid monthly allowances for May 2008. I, an order of this honorable court directing the defendant to pay the claimant the sum of 314,127 naira 40 kobo, being unpaid 1 month basic salary and leave of notice for appointment termination. M, an order of this honorable court directing the defendant to pay the claimant the sum of 20,822 naira 36 kobo, being the total sum of unremitted pension for the months of March 2007, April 2007, May 2007, and June 2007, and 20% interest per annum on the said sum from May 2008 until the same is fully liquidated. This interest rate is parallel with the remitted pension of 69,130 naira 2 kobo, which has appreciated to 248 naira 983 248,983 naira 30 kobo as of 7th of July 2021. N, an order of this honorable court directing the defendant to pay the claimant the sum of 8,147 naira 50 kobo, being the total amount deducted as National Housing Fund contribution, which was never remitted to the Federal Mortgage Bank of Nigeria on his behalf. O, an order of this honorable court directing the defendant to pay the claimant the sum of 10,069 kobo, 10,084 naira 69 kobo, being the claimant's arrears of 13 months allowance as at 20th of May 2008. P, an order of this honorable court directing the defendant to pay the claimant the sum of 14,085 521 naira 96 kobo, mean the claimant's arrears of leave allowance as at 20th of May 2008. Q, an order for payment of 20% interest per annum pre and post judgment date on the total sum starting from 20th of May 2008 until the same is fully liquidated. R, an order of this honorable court directing the defendant to pay to the claimant the sum of 5 million naira general damages for unfair labor practice, i.e. breach of contract arising from underpayments or non-payment of emolument, non-confirmation of employment at the end of probation period, and termination of employment without notice and without payment of 1 month salary in lieu of notice, non-payment of salary for the month of May 2008, and refusal to pay the net benefit, thereby subjecting to untold hardship that come with immediate employment termination without payment of net benefits despite his repeated demands for same. S, an order directing the defendant to immediately unfreeze the claimant's account. T, the cause of this action, 500,000 naira as may be assessed by this honorable court. I've summarized the proceedings at trial as well as all the submissions of counsel in their respective final addresses. I'm going straight to the diction portion. Now, I will start off with the resolution of the preliminary objection raised by the defendant. The defendant challenges the court jurisdiction to entertain this matter on the ground that the action is statute barred. This application was filed on the 3rd of February 2023 alongside the defendant's processes. Pursuant to the provisions of Order 18 Rule 2 of the NSCN Civil Procedure Rules 2017, the court directed the parties to argue this plenary objection their respective final addresses at the conclusion of hearing. I've carefully considered the arguments and submissions of counsel for and against the grant of the press sought in the face of the motion paper. Now, there are two issues before the court to determine here. One was when the cause of action in this suit arose, and two, whether this suit is statute barred. In determining issue one, I've carefully considered the peculiar circumstances of this case. The claimant here challenges the determination of his employment as the main grounds against the defendant. There are other ancillary reliefs here relating to an alleged underpayment of his monthly salaries and allowances, as well as the non-remittance of his pension deductions. It was the contention of the claimant here that the injury falls within the exceptions to the limitation law as enumerated in AG Rivers State vs. AG Bayelsa State Supra, as the defendant had breached the contract by underpaying the claimant's salary, failure to pay claims for work, and placement of a lien on the claimant's bank account. Claimant further contended that the cause of action arose when the pre-action notice was served on the defendant on the 19th of April 2021. Now, continuance of injury as defined by case law authorities means continuance of the act that caused the injury and not the injury itself. The act which caused the injury and not the injury itself. I refer to the case of Okafo was AG Anambra citation provided, as well as the case of INEC was Ogadibo local government and two others, where the apex court held that the continuance of injury means the continuous or repeat of the act which caused the injury. It does not and cannot be said to mean the concomitant effect of the damage or the injury. In this instant case, it cannot be argued that the failure to pay the claimant his full salary as alleged has continued after the termination of his employment. Monthly salaries become due at the period specified for payment each month, and with each alleged failure to pay the correct salary at the end of every month complained of, there's a repeat of the injury as in Visage versus INEC versus Ogadibo Supra. It is therefore my considered opinion that the exception of continuous injury cannot avail the claimant here and as a whole. This also applies to the alleged failure to remit the deducted pension contributions to the claimant's RSA, the lien allegedly placed on the claimant's bank account by the defendant, as well as the alleged wrongful termination of the claimant's employment. These constitute completed acts which give rise to a cause of action at their occurrence. It is therefore my finding that the cause of action arose at the termination of the claimant's employment on the 19th of May 2008, and there are no facts shown to this court that constitute an exception to administration law and as a whole. Having resolved issue one that the cause of action arose on the 19th of May 2008, I will now proceed to determine whether this suit is statute barred. This is done by checking the time the cause of action arose or accrued and the time the suit was filed. This can be ascertained by looking at the pleadings contained in the statement of claim. Reference here to the case of Malam Adamu Ibrahim and others was Alaji Isa Atayusuf. Citation provided. Where the Court of Appeal held thus, and I quote, in determining whether a suit is statute barred or not, in Chief Ihene vs. Chief Eje Rodi, citation provided, the Supreme Court enunciated that in dealing with limitation of action by statutory provision, the precise date when the cause of action arose or accrued must be determined. The time from which the bar of an action begins to run is measured by years, months, and days. That is from the date the cause of action arose. CCAC versus Governing Council, ITF, citation provider, and JACO was Only Boys Technical Services Limited, and I end quote. Flowing from the above authority, measuring thus the year, month, and date when this cause of action arose, that is in 19th of May 2008, to the date the suit was filed, which is 21st of October 2021, will amount to 13 years, 5 months, and 2 days. By that calculation, I find that this action, as constituted, is covered by the provisions of Section 18 of the Plateau State Limitation Law, which provides that no action, funded or contract, tort, or any other action not specifically provided for in parts 1 and 2 of this edict shall be brought after the expiration of 5 years from the date which the cause of action arose. Now, the claimant has contended that by the authority of NRMA, FC, and two others versus Jubola Johnson, 2019 2 Nigeria Weekly Law Report, Part 1656, 247 at 270 to 271, contracts of service are not subject to limitation law. However, in a more recent decision of the Apex Court of Mr. Michael Idachaba and others versus the University of Agriculture, Makurdi, and two others, 2021, Law Prevalent Electoral Law Report 53081 in bracket SE, the apex court seemed to have departed from its earlier decision in NRMFC Supra. In dismissing the appeal of the appellants, which was founded on their employment contract, the apex court held that a failure to institute the action within the time contemplated by law meant that it was statute barred. This is the more recent decision of the Supreme Court, and the established principle of law is to follow the latest decision in the event of what appears to be conflicting decisions. See the case of Zynet Singapore Limited versus Mofas Shipping Line Nigeria Limited and another, while Iyezoba JCA held thus that the law is well settled that where there are two or more conflicting judgments, it is the latest in time that must be followed. Serhi versus Solam, Ikeaku versus Nwakam, Ikeni versus Ifamo, Osakwe versus FC Asaba. Citation provided for all these matters and in code. I therefore have come to the irresistible conclusion that this action is statute barred. The premier objection therefore succeeds, and this suit is hereby dismissed for lack of jurisdiction. Given the lack of jurisdiction, any pronouncement on the matter would amount to a waste of judicial resources. I will therefore stop here, and judgment is entered accordingly. Parties are to bear the respective costs.
As a couple, we appreciate my lord for the erudite judgment.
Thank you. Pick up on Monday in Jos from Grace. Monday. Anything after Monday is Grace, not me. Now, please counsel Mr. Ibrahim Rabiu versus Learn Africa.
My Lord, we are here, sir.
Onyekwere and Adakole.
Yes, my Lord.
Sir. Yeah.
Mr. Adakole.
Yes, my Lord.
So Onyekwere, she with us?
Yes,
Yes,
my
she-
Lord, we can begin now.
All right. Now this is the constitution.
My Lord, sir.
Yes.
Well, appearance, I appear with my learned friend, sir.
Well, even if you appear with your learned friends, you want their names to appear on the copy of the decision, right?
Yes, my Lord.
All right, Mr. Adakole, you appear with?
Hello, I appear with UP Ogo Esquire and UP Ogo Esquire
Yes.
and UA Njoko Miss.
UA Njoko.
Yes, my Lord.
Yes.
All
All right, this is the court decision.
As a
Now,
company.
Clement, comment. So you can mute your mics, please, gentlemen. Clement comments this suit via a complaint filed on 21st of October 2019, claiming the following against the defendant. Declaration that claimant is entitled to the sum of 43,000 naira monthly as unpaid half of his monthly salary for the periods of February 2016 to November 2016, January 2017 to November 2017, January 2018 to June 2018, August 2018 to February 2019, the total sum of 1,462,000 naira only in the course of his employment with the defendant. 2, an order of this honorable court directing the defendant to pay the sum of 1,462,000 naira only as arrears of unpaid half salary to the claimant for the periods of February 2016 to November 2016, January 2017 to November 2017, January 2018 to June 2018, and August 2018 to February 2019 in the course of his employment. 3, a declaration that the claimant is entitled to the sum of 86,000 naira as monthly salary for the period of March 2019 to September 2019, culminating in the sum of 602,000 naira. 4, an order of this honorable court directing the defendant to pay the claimant the sum of 602,000 naira as monthly salaries for the period of February 2019 to September 2019, during which the claimant ceased to pay his salaries completely. A declaration that the claimant is entitled to allowances are stated below. Now, there's a table where the claimant made a tabulation of his housing allowance, car maintenance, leave allowance, medical allowance, end of year bonus, and a total sum of 3,371,561.66. Now, relief 6 for an order of this honorable court directing the defendant to pay the claimant the sum of 3,371,561.66 for unpaid allowances as stated in 5 above for the period of 2013 to 2018. 7, the declaration that the claimant is entitled to the sum of 1,710,000 being payment for security for the defendant's damaged vehicle from January 2015 till date at 30,000 naira monthly. 8, an order of the honorable court directing the defendant to pay the claimant the sum of 1,710,000 being the payment for security for a defendant's damaged vehicle from January 2015 till date at 30,000 naira monthly. An order of the honorable court directing the defendant to pay the claimant's general damages in the sum of 1 million naira. And finally, the cost of action. I've summarized proceedings and trial and all your submissions. The final address. defendant's final address, claimant's final address, the reply on points of law, and this is the court's decision. The law is clear on the nature of declaratory orders. The claimant here seeks declaratory reliefs, which are certainly not granted as a matter of course or even on admission by a defendant. See Modigo versus Yaro citation provided, Ayaru versus Mandilas, and Matanmi and others versus Dada and other. And particularly Iloria Ishola, which held that a declaratory relief can only be granted where the claimant established that he has an interest or right which forms the foundation of the relief sought. Reliefs 1, 3, 5, and 7 all seek declarations. So what has been placed before the court in proof thereof? Relief 1 seeks a declaration that the claimant is entitled to the sum of 43,000 naira monthly as unpaid half of his monthly salary for the periods of February 2016 to November 2016, January 2017, November 2017, January 2018 to June 2018, and August 2018 to February 2019, the total sum of 1,642,000 naira only in the course of his employment with the defendant. It follows, therefore, that the claimant is under a duty to place the court of what confers upon him the entitlement of 43,000 naira as half of his monthly salary. Simply put, what is the evidence that the claimant is entitled to 86,000 naira monthly at his salary? I've painstakingly gone through all the exhibits placed before the court, and I found that there is no such document that confers such entitlement or inquiry. Entitlement, not evidence of payment, not your bank statement. Entitlement, what give him the entitlement? There's no document before this court that expressly said that this is your salary for the month, 86,000 naira. Or inquiry, note that. I've painstakingly gone through all the exhibits placed before the court, and I found that there's no such document confers such an entitlement on the claimant. Self-generated computation of entitlement by a claimant is no proof of this entitlement. The claimant must provide some other evidence in proof of that which he lays claim to. In RCC Nigeria University, Edomo Won Yin. Now, citation provided. The Court of Appeal, by his lordship, JCA held as follows, and I quote: "It is tried that any claim for loss of earnings is a claim for special damage in the sense that full particulars must be given by the plaintiff in his pleading at his rate of earning and such other facts as may be necessary to enable the court to calculate as best and as accurately as he can." Say Moyen was Ojo, Benin Rubber Products Limited was Ojo, and I end quote. See also Mr. Mohamed Dungus and others with ANL consortium citation provided. For special damages, not the oral testimony of the claimant, except if corroborated by some other credible evidence, is sufficient to establish an entitlement. Now, by section 131 to 134 of the evidence of 2011, the onus is on he who assessed to prove. See also Ayala versus Daniel, Kasuki and FRN, citation provided for these matters. The burden on proof is on the claimant here. The nature of the claims before this court is in the nature of special damages. Ali versus Bulaki and Neka BBB Manufacturing versus ACB, where the apex court held that it is a well-established principle of law that special damage was special period with relevant particulars and strictly proved. Dumes Nigeria Limited versus Ogboli, Adeocean versus Adita, Osuji versus Iseocha. The claimant has not placed before the court his letters of employment, promotion, pay rise or increment. No pay slips or employee handbook is before the court. How then is the court supposed to find for the claimant? Yes, Exhibit C2, which is the bank statement, show different payments described as salary, but this is not proof of entitlement, as the court will not speculate as to why different sums were paid to the claimant for the simple reason that the agreement to pay a set sum as the claimant's monthly salary is not before the court. So hold. As was held in Dungu Supra, I quote His Lordship Kanyip. This court held that the rule is that it is the claimant who claims that must prove, and in labor relations, an employee can only claim if an entitlement is shown. An entitlement is shown by reference to the law that gives it, the collective agreement from which the entitlement was agreed upon between the contracting parties, and all the conditions of service governing the relationship of the employer and his or her employee. Secondly, the employee who claims must show how he came by the quantum of the sums claimed. This court also cautioned that it may be fatal if improving an entitlement, and even if the instrument is referred to, the employee does not indicate the said clause, section, article, or paragraph that grants the entitlement claim, given that the employee should not expect that it is the court that will shop for the relevant article that substantiate the claim paid for. This is the context within which the claimant can succeed in this case. End quote. I find that the conditions later in Dungu Super apply here. There's no proof of entitlement or of a quantum claimed. I must therefore find that the claimant has not established to the court's satisfaction an entitlement to the grant of relief 1, it's hereby refused and dismissed accordingly. As a necessary consequence, I must also also refused relief 2, which is hinged on the success of relief 1. Relief 2 is hereby dismissed accordingly. I will also adopt my reasoning and conclusion on reliefs 1 and 2 in determining reliefs 3, 4, which is relief 3, relief 4, which is hinged on relief 3, relief 5, and relief 6, which is also tied to relief 5. The same fate must befall this relief as the claimant has not discharged the burden of showing an entitlement to the grant of the declaratory orders or an award of the sums claim. There's no proof of entitlement and quantum. Reliefs 3, 4, 5, and 6 are all hereby refused and dismissed accordingly. Coming to relief 7, I find the claimant's story strange and extremely unlikely that despite allegedly being owed salary for months, which led to his failure to attend the hearing as shown in Exhibit C4. In the claimant's words, he was suffering from financial incapacitation. How then did someone in such precarious financial state pay the total sum of 1,710,000 naira out of his pocket on behalf of an employer who is allegedly owing him money? This story verges on the incredible. I'm not swayed by it at all, and I find that in the absence of compelling evidence, the 7 and 8 are unproven are also dismissed accordingly. With no wrongdoing established on part of the defendant, there exists no grounds for the grant of relief 9. It is therefore dismissed accordingly. For the avoidance of doubt, the claimant's case fails in entirety, except by dismissed parties are be prepared at their respective court. Now, for the counterclaim, judgment is entered accordingly. Now, for the counterclaimant's case is also caught up with the same issues that affected the defendant to the counterclaim's main suit. The counterclaimant also failed to place before the court how he came about the sum, how he became entitled to the sums claim. Mere tabulation is no proof, I repeat. The point has been made previously. The counterclaimant only claims that the defendant to the counterclaim owes certain sums for various years. While it can be argued that there is no dispute that some debt is owed, not even Exhibit D2 is sufficient to establish how this quantum was arrived at. Without the twin pillars of proof of entitlement and quantum being shown to the court's satisfaction, the counterclaim must be refused. It fails and hereby dismissed accordingly. Parties are to bear their cost judgments entered accordingly. Now, gentlemen, you can also pick up in Jos on Monday. Now, is okay. No, is Zaruma still with us?
We are grateful for the judgment, my Lord.
Thank you, my Lord.
Now, please, is Zaruma still with us? If Zaruma is not with us, kindly note, you're not helping yourself when you have reliefs numbered from A to T. I mean, by mere repeating or loading as many reliefs as possible, that doesn't mean that you have a greater chance of success. I mean, for each one, you're under an obligation to prove each particular one. And most of the time, you lose focus as to the ingredients of what you need to prove for each particular relief. Onyekore, that's for Zaruma. I was going to point that to Zaruma and Shino there. Onyekore.
Yes, my Lord.
Now, for your own particular case, it is possible that money is being owed, right? But there was, like I said in the decision, there was nothing that shows an entitlement to it.
Yes, my Lord. We understand, sir.
You didn't place anything that says at the end of the month, this is your salary. So that if you know that this is the salary, right? That means you can now say this is the shortfall.
Yes,
there can be an explanation for why this month there is this salary, and then the next one there is. It could be that he was working on commission, who knows? But that would mean the court would not speculate. But once you establish that this is how I came about my entitlement, and this is the document that gave me the entitlement, and this is how I arrived at the quantum, the results could have been different. You can pick up in Jos anyway tomorrow. Okay?
All right, thank you,
I wish you a good vacation.
Yes.
Now, there are some other matters for
adoption, my Lord.
Adoption of what?
Terms of settlement.
Of terms of settlement.
Yes,
Not adoption of final addresses.
Sir?
Not adoption of final addresses.
Yes, no.
You adopt final addresses, you're on your own.
That's serious.
I didn't even know I was going to be able to deliver these judgments. But when did you file the terms? Now for Dr. James Mato Guang, and Plateau State University, Bokos, and Plateau State, and the Governing Council of Plateau State University, Bokos. Do we have counsel?
Yes, my lord. Good morning, my lord. For the claimant.
Good morning, my lord.
There.
I'm from the defendant.
Yeah, Tunde is for the claimant.
Yes.
Your school represents for the defendant.
I.O. Haruna, my lord, for the defendant.
I.O. Haruna. Yes, please. Yes, Nze.
Yes, my lord. The terms of settlement between parties herein is dated.
We filed our terms of settlement
On the 6th day of June.
6/6/2023.
Yes, my lord.
Adopting
as
urge the court to enter it as a judgment.
the court presents. Thank you, my lord.
Haruna will also adopt same. Haruna.
Yes, my lord, we humbly adopt same and urge this court to enter same as our consent judgment.
The terms of settlement filed on the 6th of June 2023 and adopted by the parties today is hereby entered as the judgment of the court.
The court pleases.
Jesus. Thank you, my lord. And may I
you.
take the liberty to congratulate my lord for the well-deserved elevation.
So is today you're congratulating me, Nze?
It's today I have the opportunity to appear before my lord.
Thank you.
Thank you, my lord.
For Haruna that doesn't want to congratulate me, don't worry, I know my friend.
Congratulations, my lord.
I know my friends, don't worry, Haruna.
Congratulations, my lord. Thank you.
Now for Mr. Shishke Anthony Auta and UAC Foods and Unico CFA Limited. Do you have counsel?
Yes, we are in, my lord.
Yes, appearances, please.
My lord, P.A. Daclexa for the claimant. My lord, Bitrus Dum for the defendant.
Yes, Mr. Dakilek.
Yes, my lord, the terms of settlement was filed on the 20th day of June 2023, sir.
You adopt him and you urge the court to enter it as a judgment, right?
Yes, my lord.
Mr. Doom?
Yes, we adopt him, my lord.
The terms of settlement filed on the 20th of June 2023 and adopted by the parties is hereby entered as the judgment of the court.
As the court please.
Monday as well. Monday as well.
Opportunity to congratulate my lord too.
Mr. Doom, you're in a hurry so that I will say you're not my friend.
My lord, it's fine.
Best friends, my lord.
Yes, sir. We equally want to use this opportunity, sir, to congratulate my lord on the well-deserved elevation, sir.
Thank you. I invite all of you for the party. If that is, since that is what you want.
That claim is not my lord. Just
But God places.
Oh, you don't want to come for the party?
will come.
You will come, are you?
Will come, my lord.
Yes, sir.
Mr. Sunday Jonathan Akma, an honorable Attorney General, Plateau State and Plateau State Government.
Yes, my lord.
Appearances, please.
My lord, J.I. Montu, an assistant director with the Citizens' Rights and Ministry of Justice.
Are you not on strike? Are you not on strike?
No, we're back. We're back. We've resumed.
When?
That was 2 weeks back.
Okay.
Yes, my lord.
For the defendants?
Yes, my lord.
Who appears for the claimants?
For the claimant, my lord, LD Dafer.
LD Dafer.
LD initials, Dafer, DAFER, my lord.
For the claimant, right?
For the claimant, my lord.
Mr. Dafer?
Yes, my lord, our terms of settlement was filed on the 10th of May, 2023. My lord, I most respectfully adopt them, and I urge Honorable Court to enter judgment accordingly.
Yes, please.
Yes, my lord, that's the true position. We urge the court to enter the terms.
You need to inform the court that you are adopting it.
Yes, my lord, we adopt same.
You adopt same and you urge the court to enter it as a judgment, right?
Yes, my lord, yes, my lord.
The terms of settlement filed on 10/5/23 and adopted by the parties today is hereby entered as a judgment of the court.
We appreciate, my lord, and congratulations to my lord.
Thank you, Mr. Mantu. Where is Mr.
I want to add, my lord, that indeed Jos is the launching part. You are immediate.
Because of Amadi.
You are,
sure, my lord.
It's always like that, my lord.
So
it's
now
always like that.
You're going to start making all our judges to want
come to Jos.
Come to Jos, please, my lord.
As the God pleases, this is the second, my lord, historic.
Okay.
Yes.
So
yes,
we hope the next person that comes to Jos will be elevated as well.
Amen.
Certainly, my lord. We pray along.
God pleases.
Wish you the best over there, my lord.
Thank you. And
the very best, my lord.
Thank you very much.
Thank you, my lord. Yes, my lord.
Now for Plateau State Board of Internal Revenue, Plateau State Government, and Mr. Stephen Mara.
Yes, my lord.
Who is counsel?
M.M. Mandong, my lord.
Yes. For
the judgment creditor applicant, my lord.
Applicant?
Yes, my lord.
Okay. Yes.
My lord, the other counsel is online, my lord.
But I need for him to come online. That's Mr. Yilvoms.
Yes, sir.
Mr. Irwam, if you can hear the court, please indicate so. Because we cannot proceed.
I think NE Tokular it's online, and I don't know why she's
we cannot proceed without opposing counsel. One council cannot adopt the terms and then look for the court to enter its decision.
As a court pleases, sir.
If you are not ready today, there will be another Zoom proceedings on Tuesday.
Okay,
that will be for Lagos Division, but you could also log in.
As a court pleases, sir.
Because we cannot proceed without you. Both parties need to be in court.
We agree with my lord, sir.
So, Irvams is not here, and Tokula, you said, right?
Yes, sir.
My lord, I'm here. But I can't hear it. It's as if I've been muted.
No. So, can I take your appearance then? Can I take your appearance then?
Mandong.
For the judgment creditor applicant, right? Pecula, please.
Yes, my lord, I'm online.
So,
I don't know. It's as if I've been muted.
We can hear you. Just give us your appearance. That is all.
Thank you, my lord. S.E. Tokula, my lord. I hold the brief of A.G. Irvams.
For the
judgment, debtor respondents, my lord.
Yes, Mr. Matnon.
Yes, my lord. We have filed our terms of settlement on the 25th day of May, 2023. And we humbly adopt same. And urge this court to enter.
We humbly adopt him, my lord, and urge the honorable court to enter him as a consent judgment between the parties.
Terms of settlement filed on this 25523 and adopted by the parties today is hereby entered as the judgment of the court. Did you hear that?
As court pleases, we are grateful, my lord.
All right, so you can pick up in just, yeah, you can pick up in just on Monday as well, okay? So thank you, gentlemen. Have a good vacation.
Thank you, sir.
Congratulations,
my lord.
All right, thank you.
This is the opportunity to, may I use this opportunity? I wish to humbly congratulate my lord too on this well-deserved elevation. We pray for wisdom upon my lord up there.
Mm.